Supreme Court of India Wahid and Anshu vs. State Government of NCT of Delhi decided on February 4, 2025 Manu/SC/0145/2025 Facts of the case. The prosecution case is that while complainant, prosecution witness 1, was traveling along with 4 other passengers, driver and conductor in bus, 4 persons boarded the vehicle and threatened the passengers with knives, screwdriver and country-made pistol, robbed them of their mobiles and cash and deboarded the vehicle. The driver thereafter took the passengers/victims to nearby police, PCR. The police officer present there was apprised of the incident and later a formal first information report was registered. Appellant Wahid was convicted by the trial court for offence punishable under Section 392 read with Section 397 IPC, but acquitted under Section 411 and Anshu was convicted and sentenced under Section 392/397. Besides that he was also convicted for offence punishable under Section 25(1) of the Arms Act. High Court dismissed the appeal. Findings of the court. Having perused the materials on record, we find that prosecution has succeeded in establishing that on the night of December 3, 2011 the travelers of Gram and Sua were robbed by 4 persons, who entered and exited the vehicle together after looting the travelers of their belongings such as cash and mobile phones, under threat of knife, country-made pistol and screwdriver. In respect of the above allegations, there is no discrepancy in the FIR and the eyewitnesses, i.e., travelers, conductor and driver of Gram and Sua, account. Moreover, the FIR of the incident has been lodged at the first opportunity. However, mere proof of robbery is not sufficient to hold that the accused persons who were put to trial were the ones who committed the offense. In cases where the FIR is lodged against unknown persons, and the persons made accused are not known to the witnesses, material collected during investigation plays an important role to determine whether there is a credible case against the accused. In such type of cases, the courts have to meticulously examine the evidence regarding a. how the investigating agency derived clue about the involvement of the accused in the crime, b. the manner in which the accused was arrested, and c. the manner in which the accused was identified. Apart from above, discovery/recovery of any looted article on the disclosure made by, or at the instance of, the accused, or from his possession, assumes importance to lend credence to the prosecution case. Manner in which accused persons were arrested and recovery effected appears doubtful. Taking a guarded approach, we have therefore carefully examined the prosecution evidence to be satisfied about the truthfulness of the prosecution story. Having done so, we found that there appears some discrepancy in the statement of prosecution witness 10, i.e., Head Constable Mursaleen, posted at Police Station Nan Nagri, and prosecution witness 13, i.e., Narendra Singh Rana, the investigating officer of the case, regarding the place where they received information about the presence of the accused persons at the bus depot, from the statements of key witnesses extracted above, and on cumulative analysis of the circumstances discussed above, while taking into consideration the statements of accused appellants recorded under Section 313 of the Code of Criminal Procedure, 1973 that they were picked up from home and falsely implicated by the police, a serious doubt is cast on the manner in which the prosecution claims to have arrested the accused. Unfortunately, the High Court and the trial court were not circumspect while evaluating the prosecution evidence and thereby failed to test the prosecution evidence on the anvil of probability as was required in the facts of the case. For the reasons above, we hold that the arrest of the accused persons in the manner alleged by the prosecution is highly doubtful and unworthy of acceptance. Once we doubt the manner in which the accused were stated to have been arrested, the alleged recovery of screwdriver, knives and country pistol made at the time of arrest is rendered unacceptable. Moreover, weapons/articles allegedly recovered are not so unique that they cannot be arranged. Identification by few eyewitnesses not reliable. In such circumstances, and in absence of corroborative evidence of recovery of looted articles at the instance of or from the accused persons, in our view, this was a fit case where the appellants should have been given the benefit of doubt. In view of the analysis and conclusions above, these appeals are allowed.